Hi, I'm Alexander Haberbush, president of the Lex Rex Institute and a practicing constitutional attorney. And as always, nothing in this video constitutes legal advice. Okay, so let's take a look at today's question. Okay, what are the limitations on the freedom of religion? What if my religion says that I should steal from everyone or burn down all blue houses? Okay, well, obviously the free exercise clause of the First Amendment, which is sort of the part of the Constitution that is in direct reference with this question, obviously that does not protect your ability to steal from people or to burn down houses. But why doesn't it? Let's take a little bit of a dive in and see if we can figure out why that is. This is sort of a complicated question, so I'm going to start by going over sort of the history behind why we have the religion clauses of the Constitution at all, then talk about some of the jurisprudence, past rulings about this issue, and then finally give an answer. This is far from a settled or a certain area of law. The court has been kind of schizophrenic when it comes to free exercise clause issues, so I'm going to try to explain to you why that is. Hopefully this doesn't take as long as the last couple of weeks' videos, but I do want to make sure that you guys get a basic understanding of exactly what's going on here. So before we jump into the direct question, let's just take a look at the two clauses that are going to be in reference here. Okay, so both of the clauses we're talking about are in the First Amendment of the Constitution. As you remember, first 10 amendments are part of the Bill of Rights, which were sort of suggested by the Anti-Federalists as ways of controlling the rest of the Constitution, which was seen as broadly enabling federal power. So specifically, we're going to look at the first part of the First Amendment, which says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Okay, so two clauses. First is the one about Congress shall make no law respecting an establishment of religion. Second one, prohibiting the free exercise thereof. The second one is the one that we're going to be looking at today predominantly. But I think that both of these clauses do inform each other, so I want you to keep in mind that the establishment clause is also sort of at play, even though it's not directly at issue here. What do I mean by that? Well, okay, so sometimes these clauses historically, especially by the court in sort of the later half of the 20th century, these two clauses have been read in opposition to one another. Let's take a look at them again. So broadly speaking, sort of the way that it was viewed to work was that the Establishment Clause prevented the government from giving any sort of support to religion, usually a particular religion, especially making that religion the official religion or a state religion of any kind. That was state religion, and pretty much everybody agrees that's prohibited by the First Amendment. Beyond that, what kind of support can be given, that's a highly contested issue. And the court does tend to go a variety of different ways on that. And the free exercise clause was just sort of broadly viewed as a clause that sort of prohibited anything that would infringe on somebody's freedom of conscience. So that clause was broadly viewed as giving people freedom of conscience, whereas the Establishment Clause was viewed as a prohibition on the promotion of religion. So you can see why these might come sort of at odds with each other in the view of the court, because on the one hand, you're trying as best you can to make sure that people are able to practice their religion freely. Well, but when does that become a state endorsement of religion? Lots of examples could come to mind about that. I mean, for instance, if you did have a religion that said that you're supposed to burn down all blue houses, and the government made a law saying you could burn down blue houses, well, that would sure seem like a law that gave preferential treatment to that religion, wouldn't it? And that could potentially run afoul of the Establishment Clause. So you can see where, for a lot of the history of the court, these two clauses were sort of balanced against each other. But I'm not at all convinced that's the way that the Founding Fathers would have viewed this at all. And to understand what I mean, just sort of look at the social and historical context in which the Founding Fathers lived. Now, I think it's sort of common knowledge that many of the early settlers in the English colonies in the New World, in America, were people who came here because of various kinds of religious persecution. Now, keep in mind, in Europe, for about 1,500 years, the Roman Catholic Church had been the only official church, and it was the recognized state church in virtually every country in Europe. Then a little thing starts to happen called the Protestant Reformation, where people begin to challenge the hegemony of the Roman Catholic Church. One of the first countries to do this, famously under Henry VIII, is England. As we remember from some of our past videos, America does inherit the English common law system, although we do make modifications to it, especially a few constitutional modifications to it. So Henry VIII declares independence from the Roman Catholic Church, creates the Church of England, and then for the next couple centuries, what happens is the English throne waffles back and forth between Protestant monarchs and Roman Catholic monarchs. Whenever a Roman Catholic is on the throne, they kind of persecute the Protestants, and whenever a Protestant's on the throne, they can persecute the Roman Catholics as well, although usually to a lesser extent. Obviously, Elizabeth I did nowhere near as much to persecute Roman Catholics as Mary did to Protestants, but you get persecution of both kinds, and people flee that coming to the New World. And when they get here, what they do is they set up their own colonies, which enshrine sort of their own state churches and say that we're going to run things according to the standards of this or that religion. In Massachusetts, you have the Puritans, which is a very Calvinistic sect, and the laws reflect that in Massachusetts. In Maryland, you have really, Maryland, sort of a Roman Catholic colony, and there, the laws were very protective of the rights of Roman Catholics. So, ideological considerations aside, I do believe that the Founding Fathers sincerely believed that people ought to be free to practice their conscience when it comes to religion, and I agree with that as well. You get some profound statements about that from both Thomas Jefferson and from Madison. We'll talk about Madison a little bit later, since he's one of the principal authors of these First Amendment clauses. But even if they hadn't had a principled support for the idea of free exercise of religion, when you look at the fact that all these different colonies have all these different ways of doing things, well, on a national level, when you start drafting a federal constitution, it becomes pretty obvious that if you try to respect one of these groups over and against the others, you're not going to get people getting along too well. So we do end up getting these two clauses. James Madison, I just mentioned, he understood the import of both of these clauses to be that Congress couldn't enforce or establish a religion, and it couldn't enforce the legal observation of any religion by law, nor could it compel men to worship God in any means other than what their conscience dictates. That's what he understood both of these clauses to do. So they were meant to be read as complementary to each other, not opposed to one another. So in both instances, sort of with both clauses, the organizing principle that Madison is drawing our attention to is the avoidance of compulsions upon the conscience of people who are only trying to worship God in their own ways, free and unmolested. And significantly, Madison and the rest of the framers of the Constitution as well did not view these clauses merely as protecting beliefs. They viewed them as protecting practices or exercise as well. That ought to be somewhat obvious from the fact that the Free Exercise Clause pertains to exercise of religion. Exercise is not something you do purely in your heart or in your mind. Exercise is something you do through your practices. And this is reflective of sort of the Christian religion that was held by many of the framers of the Constitution, particularly one that was sort of picked up from the culture, and which many of them believed as well, that was sort of a culturalistic Calvinism. And for those familiar with the Reformed faith, you're aware that the Reformed believe that all of life is lived before the face of God. In other words, God's commands pertain to every area of life. So free exercise of religion must necessarily affect the way that people act, in addition to just the things that they believe. So that's sort of the way that the Free Exercise Clause was set up when our Constitution was ratified. Now, the very first ruling that we get on the Free Exercise Clause is going to be in the case Stansberry v. Marx. That's, I think, a 1793 case. And what that case had to do with was a Jewish man who had been subpoenaed and was going to be compelled to testify on the Sabbath. Well, Jews are not allowed to do work on the Sabbath. That's part of their religion. They're not allowed to engage in any kind of work. And I guess that the Sabbath prohibited him from testifying on that day as well. The court tried to compel him to do so anyway, and nope, he is told on appeal, the court says, no, he has a right not to testify on the Sabbath because of the Free Exercise Clause. That's the exercise of his religion, is observing the Sabbath. So right there at the very beginning, first case we get on this, keep in mind, this is an important point as well, but keep in mind it's protecting a religious minority. Jews were not the religious majority in any state in the Union. So clearly it's not just for the rights of those who are in power, it's for others as well. And then secondly, what we get is a law that says that even though we have this law saying other people have to testify on the Sabbath, this Jewish man gets an exception to it. Well, why does he get this exception? And this ought to be drawing your mind to the idea of laws of general applicability, which we'll get into a bit when we talk about other court precedent on this. But even though it's a law of general applicability, he is able to get exception from it. And then thirdly, it's protecting his religious practice, not just his religious belief, since observance of the Sabbath is something that you do, not just something that you believe. Now, a distinction begins to enter the jurisprudence between belief and practice about, well, I guess it's about 80 years after this. And this occurs in a case called Reynolds v. United States. This is an 1878 case. And what this case had to do with was a Mormon polygamist who lived in the territory of Utah. Utah was not yet a state, but it was a U.S. territory. And as we know from the Constitution, Article 1, is that Congress is able to create laws for territories. So states create laws within the jurisdiction of a state, but if something's a territory, there is no state yet. So Congress creates the laws with respect to territories. And there was a federal law defining marriage as a monogamous relationship between a man and a woman. Well, obviously, polygamy does not fit within that definition. He argued that the Mormon religion compelled him to have more than one wife, or at least to be morally right, he had to have more than one wife. And the court in this case rules against him. But the court, which might seem strange based on previous precedent that we had. Now, obviously, I think somebody trying to get married to multiple wives is sort of a more more socially, has more social ramifications, I suppose I should say, than one guy not testifying on the Sabbath, or even a whole group of people not testifying on the Sabbath. And that's exactly what the court says. They say that monogamous heterosexual marriage is so important to society that essentially the interests of the state in protecting that institution outweigh this Mormon person's, I guess, Reynolds' right to freely exercise his religion. So what we get introduced at this point is what's become all too familiar in constitutional law, a balancing test, where you balance the interests of the state against the religious person's right to freely exercise their religion. Now, the court does waffle back and forth on this for the next, well, about a little over 100 years. But the precedent that is established in this case is that religion is protected only insofar as it does not threaten public order. This is often referred to as the public order exception to the Free Exercise Clause. Now, in the case Sherbert v. Werner, that's an early 20th century. I forget the exact year on that one. But in that case, we see a Seventh-day Adventist who was fired from her place of work because she couldn't work on Saturdays. And I guess her employer was compelling her to work on Saturdays. So actually very, very similar to the case of the Jewish man that we talked about a moment ago. And this case actually kind of finds the opposite way from Reynolds. What it finds is that she does have a protected right. Well, okay, so a few more facts on this case. She gets fired because she wasn't working on Saturdays, and then she applies for unemployment in her state, which I think was North Carolina in this case, though I'm not certain on that. And North Carolina had a law saying that you couldn't apply for unemployment if you had been terminated for good cause. And she's saying, I wasn't terminated for a good cause because I was just trying to practice my religion. Well, the court ends up finding in her favor. And what this case does significantly is it says that free exercise claims are given strict scrutiny. Well, what's strict scrutiny? I think we've talked about this in the past video, but whenever the court's applying a balancing test, it has different levels of scrutiny that it'll apply to see basically how important the interest or the right being protected is relative to the state's right that it's trying to balance against. And all you have to know for purposes right now is strict scrutiny is the very highest standard that the court can apply. It's the hardest standard to meet, burden of proof's on the government, and they have to show that there is a compelling state interest narrowly tailored to the instance at hand. So that case establishes strict scrutiny for religion. So again, already a little bit of waffling back and forth on how exactly the court's supposed to be treating free exercise claims. This continues. I won't get into all of the cases on this because there are really a lot, but sort of the red letter case, one that really matters for our purposes because it changes this whole schema, is going to be Employment Division v. Smith. That's a 1990 case. And in this case, what the court examined was a man who was a member of, I'm going to forget which Indian tribe. He's a member of a Native American tribe. And his tribe believes that that smoking peyote, I don't know if you smoke peyote, but however you imbibe peyote, which is a hallucinogenic plant, they believe that using peyote was integral to their religious practice. And this man, the facts are very, honestly, I think the facts end up being what determine this law. There's an expression in law that bad facts make bad law. I think Smith may well be a very good example of that because the facts are aligned just so that you wouldn't want to side in favor of Smith. But basically, Smith worked at a drug rehab clinic, and then he came to work while high on peyote. And his employer, seeing that he was high on peyote and that peyote was illegal in Oregon, fired him on the spot. Well, like in the Sherbert case, Smith applies for unemployment in Oregon. Oregon has a similar law to what was at stake in the Sherbert case. And Mr. Smith ends up being denied his unemployment. Well, he argues that he shouldn't be denied unemployment because he was only practicing his religion when he was fired. And the court finds against him. And not only do they find against him, they actually get rid of, in some instances, the strict scrutiny test that is applied in free exercise cases. Believe it or not, Scalia wrote this opinion, commonly regarded as one of the more conservative justices, certainly an originalist justice, but he wrote the majority opinion in this case. And what he said is that free exercise cases do not get strict scrutiny if what they apply to is a neutral law or a law of general application or general applicability. What does that mean? Well, it means that if the law is not one that targets a religious practice, it's just one that's sort of generally applicable, one that's passed for a variety of other reasons, really any valid legislative purpose, and is neutral. That is, it doesn't target one religion at the expense of another, or at least does not appear to consciously do that, then that does not get strict scrutiny. That law is subject to rational basis review, which is the lowest form of review. Government almost always is able to satisfy that. However, free exercise claims do still get strict scrutiny if they involve another law. If the law involves another constitutional provision that does get strict scrutiny or even gets any kind of scrutiny. And that would be something like freedom of speech or freedom of the press. So if more than one issue is implicated in the same thing, that's often the case. Oftentimes, things that are a religious practice are also something that have expressive conduct and thus are therefore part of a free speech protection. If that's the case, it would still get strict scrutiny. Or if the law targets a religion in a way that's not neutral or generally applicable. Now, how strict is the court on this general applicability standard? Well, we know in other things it's pretty strict. For instance, in Brown v. Board of Education, separate but equal was ruled unconstitutional, treating different races differently, but allegedly equally. Well, that law was said not to be generally applicable because it respected one group at the expense of another, even though there was nothing in the law saying that white people are supposed to be given more rights than everybody else. It was clearly applied that way. So being in application non-general is sufficient to be able to show that the law is not one of general applicability. And this is shown very soon after the Smith decision in a 1992 case. I'm sure I'm gonna butcher this name, and I apologize. It's Church of Lukumi Babalu Avenue versus City of Hialeah, I think is what it's called. But what's going on in this case is Florida has a law saying that nobody can sacrifice animals as part of a ritual, and then I think for any reason other than primarily for consumption, I think is what the law said. And even though that didn't target any particular religion, and even though it was a law of general applicability, it applied to all religions or even non-religions, even non-religious rituals for that matter, the court said that this is clearly a law that is targeting religion, and therefore this is one that, even under the Smith standards, would still be found unconstitutional. So that's sort of the state of the law right now. There have been a few more cases on this issue, notably there's the Hobby Lobby case, which again respected the rights even of large organizations to practice their religions. And then there is of course, the Masterpiece Cakeshop case. That's actually a case on which I filed an amicus brief. We'll attach that brief to or rather link that brief in the description on this video so that you can take a look at that. But needless to say, this is an issue that I care about a great deal and one that I've done work on in the past. But I did write an amicus brief in that case, and we will link that in the description. So, how do we make sense of all these different ways that the court wants to treat free exercise of religion? Well, as you guys know, or maybe for those who are new to our channel, I believe the Constitution ought to be interpreted the way that it would have been understood by somebody reading at the time that it was written. This is called originalism. And significantly, we ought to look at the way that people would have understood various phrases in the Constitution. I think the significant phrase here is going to be free exercise of religion. Well, believe it or not, that phrase is actually used in a number of state constitutions, or was used in the time of the number of state constitutions. So I think it's plausible to say that the majority of people reading it at the time would have understood that phrase to mean the same thing that it means in that context. For instance, here we've got the New York Constitution ratified in 1777, where you can see that in the highlighted portion that free exercise and enjoyment of religious profession and worship shall forever hereafter be allowed, and that is conditioned upon, look at the end part there, shall not be so construed as to excuse acts of licentiousness or justify practices, and here's the important phrase, inconsistent with the peace or safety of this state. And you see this language in a lot of other state constitutions. Notably, it's in the New Jersey Constitution. It's also in the New Hampshire Constitution. There's also something very similar in the Delaware Constitution. It's a common provision in the state constitutions prior to ratification of the federal Constitution. So what we begin to see in the majority of these state constitutions is that the freedom to exercise one's religion exists insofar as it does not interfere with the state's right, or rather the state's duty, to protect public peace and safety. Now, that might sound very similar to the public order exception to you. So if free exercise applies except for when there's an exception applying to public order, how is that different from we're able to exercise our religion freely except up to the point of interfering with the government's right to protect public peace and safety? Well, I think notably, to talk about the difference here, because I do think those are different, and I'm going to spell out how, but to talk about those differences, I think it's important to talk about the nature of balancing tests in general. And I think we're coming out with a video on this in the near future where we address the idea of balancing tests in the Constitution. But significantly, looking at the public order exception, what goes on there? Well, we know on the one hand, the person who is trying to freely exercise their religion, they have a very significant interest. Their interest in freely exercising their religion, one of the highest you can have. And then on the other hand is the state's interest in whatever policy goal they're trying to advance by the law in question. Now, that could be anything. That could be, protecting the environment. That could be ensuring that unprivileged kids are able to read. There's a lot of different things government could be advancing that are legitimate policy goals. Not all those things are public peace and safety. Not all policy goals are public peace and safety. And significantly, when we look at the balancing test, I think what's sort of implied by balancing these two interests against each other is sort of a utilitarian calculus that's going on. Which of these rights is more important? Is it more important that we make sure that underprivileged kids read, or is it more important that that this person be able to freely exercise their religion? Or to use the original asker's example, is it more important that somebody be allowed to go around burning down blue houses, or is it more important that people be able to live in their houses unmolested? And you'd balance these two things, you'd come out with which one is more important, and that's the winner. And that's sort of the strict scrutiny standard that's applied with these balancing tests. I don't think that the constitutional way of understanding it, the originalist way of understanding it, the protect public peace and safety understanding, I don't think that a balancing test is implied there. I don't think that you're trying to say that one right is more significant than the other. You are saying that free exercise of religion simply does not apply in instances where the government is passing laws for the purposes of public peace and safety. So that would be a very clear answer to the person who's trying to burn down all blue houses, because they are directly interfering with somebody else's rights. So that would be the standard that I think would be correctly applied here. You can never, in any circumstances, practice your religion in a manner that interferes with somebody else's rights. You know, freedom of religion is not just license to go around doing whatever the fact that you want and not have consequences for the things that you say or the things that you do. Your religion and your religious beliefs still absolutely have consequences. You just also have the right to freely practice them. Okay, another important consideration to keep in mind, and this is recognized by the courts as well. Courts will never look into the sincerity of a religious belief. I'm sorry, I said that exactly backwards. Courts will only look into the sincerity of religious belief. They will never look into its validity. So one of the can of worms that could potentially be opened by courts inquiring into free exercise of religion is the idea that courts are going to be approving or disapproving various religions, saying which ones are real religions versus which ones aren't real religions. Courts can never say that. That's well-accepted Supreme Court precedent. They cannot inquire into the validity of a belief. They also can't inquire into how rational a belief is. You can have a belief it's the dumbest belief in the world. The only thing the court's allowed to look at is whether or not that belief is sincerely held. So that's an important consideration to keep in mind. Yeah, I think that pretty much summarizes. You could get a lot more in depth on these issues pertaining to the religion clauses, but I think that's going to cover us for today. I see that we're already pretty long for our video. So I do think that this is where we're going to leave it off. Again, Lex Rex Institute brings a lot of cases defending people's free exercise rights. We've done this particularly in regard to the COVID-19 pandemic, with people who are validly claiming religious accommodation or religious exemption from the COVID-19 vaccination mandates, or even testing mandates, or any other thing someone's trying to make you do that infringes on your right to freely exercise your religion. We will protect those rights. As I mentioned earlier, I wrote an amicus brief in the Masterpiece Cakeshop case. We actually did win that case. The plaintiff in that case was allowed to continue selling his cakes and was not required to provide those cakes for same-sex weddings. That's that case, the same-sex wedding case. Same-sex wedding case. We were able to get him free exercise clause protection such that he was able to decline to bake cakes for same-sex weddings. Lex Rex Institute will continue to defend these sorts of religious rights. So if you know anybody, or you personally have had your free exercise rights violated, or you're not sure if your free exercise rights have been violated, since the court can go a lot of different ways on these things, give us a call. We do offer free 30-minute consultations. As you know, a lot of people who are bringing these sorts of claims are not people with deep pockets. If you feel moved to contribute, we always appreciate those contributions. This has been a presentation of the Lex Rex Institute. Again, my name is Alexander Haberbush. And thanks for joining us in upholding our Constitution. If you do have any questions that you want submitted in our Ask an Attorney series, feel free to ask them in the comment section below, or you can send them in on Facebook or by email. However you want to get those to us, that will be fine. These come out on Friday afternoons. I'm recording this on a Thursday evening. It's actually 8:45 right now, so I'm kind of eager to get home. But this will go up tomorrow afternoon. So yeah, if you have any questions, go ahead and submit those. We'd love to hear from you. This has been a presentation of the Lex Rex Institute. Thank you.